Um, Good morning. Thanks everyone for coming. You know the old saying, never follow a better act, so they let me go first. I'm going to be talking about Section 1983 updates and law enforcement liability updates. And a lot of the stuff I'm going to go over this year is a little bit bigger picture stuff because there have been some significant developments that I think are going to affect 1983 cases over the next few years. In particular in the Seventh Circuit. When I started 20 years ago, the Seventh Circuit was full of Republican appointees, fairly conservative, and it was a pretty favorable place for defendants in Section 1983 cases. Over the last 20 years, we've gotten a lot more liberal, Democratic appointees, and the tone has shifted at the Seventh Circuit, and it's a little bit more favorable for plaintiffs than it used to be, and that's starting to show up in some of the development of the law that's coming out of the Seventh Circuit. I'm going to start with a couple of recent Supreme Court cases, particularly in the areas of Fourth Amendment and due process. And the first one comes right out of Central Illinois. It's the Manuel versus Joliet. And the kind of takeaway lesson from this is that the Fourth Amendment establishes the standards and procedures governing pretrial detention, and those apply even after the start of legal process. Now, prior to Manuel, the Seventh Circuit had a pretty straightforward system for determining which constitutional amendment applies to your claim. If you think of a criminal case and the process that it goes through, it begins with an arrest, and the person is taken to jail, and within 48 hours they have to have what's called a Gerstein hearing, which is a probable cause hearing to determine whether there's probable cause to continue to hold that person if they haven't posted bond. So that is the beginning, really, of the legal process. And then, assuming that there's probable cause and they don't post bond, they remain in jail until their conviction. And so the Seventh Circuit had decided that the Fourth Amendment was what applied from the moment of arrest, when you're initially seized, up into the point of the Gerstein hearing. And from the Gerstein hearing until conviction, the 14th Amendment due process clause applied. And then after conviction, the Eighth Amendment cruel and unusual punishment clause applied. It was a very simple, straightforward A, B, C. You knew what applied. In Manuel, the court changed that and decided that the Fourth Amendment applied to seizures even after the Gerstein hearing. Now, this case was dismissed early on, so the facts were taken from the allegations of the complaint rather than evidence that developed during the trial. But the allegations were that Mr. Manuel was a passenger in a car during a traffic stop. And after the traffic stop, the officers dragged him out of the car, yelled some racial epithets at him, searched him, and discovered a single pill on him. And the officer believed that the pill was an illegal drug, so he field tested it, and the field test was negative. And he decided, well, I know this is an illegal pill anyway, even though the field test was negative, went ahead and arrested Mr. Manuel, took him to the police station. They had the pill sent off to the state lab to be tested. And a week or so later, it came back and it was negative. It was not an illegal drug or anything. 30 days later, he was finally released. So he spent about 37 days in jail, basically without any basis for being there. And he filed suit 2 years later, and the statute of limitations in Illinois is 2 years. And he filed suit just a few days past 2 years from the date of his arrest. So claims arising from his arrest were barred by the statute of limitations, but he still had this longer detention, and he claimed that he had a Fourth Amendment claim based upon that. The Seventh Circuit looked at it and said, no, you would have a Fourth Amendment or 14th Amendment claim, which is a deliberate indifference standard, which is a much higher standard than the Fourth Amendment reasonableness standard, and they dismissed the claim. It went up to the Supreme Court, and the Supreme Court said, no, the Fourth Amendment governs the standards and procedures for pretrial detention, so he could still make a Fourth Amendment claim. So there's going to be overlapping times where the Fourth and 14th Amendment may apply to different claims. So that's going to expand the potential for liability for officers who are involved in detention and involved in these arrests because we've increased the amount of time that lower standard is available. The Fourth Amendment reasonableness standard is a much easier standard for plaintiffs to meet than the 14th Amendment deliberate indifference standard, which requires more knowing, deliberate violation of the person's rights. So the next one that's significant for us is County of Los Angeles versus Mendez. This had to deal with the provocation rule arising out of the Ninth Circuit. The Ninth Circuit has maintained this for a long time, and what the basis of it was, particularly in excessive force cases, you might have an instance where if you look at just the moment the force was used, or that officer making that decision at that moment, it might appear reasonable. But if you go back in time and look at the events that led up to that there were some violations leading up to that that ultimately contributed to that need for the use of force. And if they hadn't made the errors earlier on, that the use of force would not have occurred. And this led to the development of a provocation rule, where essentially if the officers had provoked a violent response from the person they were trying to arrest, then their later use of force would not be deemed reasonable. And so this case arose out of a search for a fugitive named Odell. And the task force received information that Odell was at a house in a rural part of California. So they went to the house to look for him, and a couple of officers went up to the main house and tried to talk to the people in the house and find out if Odell was there. And a couple of other officers went and started searching some of the other buildings on the property. There were a number of storage sheds and that kind of thing. And one of the other buildings on the property was a shed that had been built by Angel Mendez, which was just a plywood board shed with no heat, bathroom, anything like that, just a shed. But that's where he and his girlfriend were living at the time. And he kept a BB gun in there to keep the rats away. So the officers eventually got to this shed. One of the officers, Deputy Conley, I think, went into that shed to see what was in there, didn't announce or anything before he went in, just went into the shed. Mr. Mendez, who was sleeping on a futon, thought one of his other friends was coming in to sleep on the futon too, so he reached to pick up the BB gun and move it. The officer saw that, yelled, "Gun!" They all shoot Mr. Mendez, and obviously the predictable result happens, and he got shot. He made a number of claims, number one for the warrantless entry, number two for the knock and announce rule, number three for the excessive force. And there were a couple of officers involved in the shooting. In addition to Conley, and Officer Peterson was one of the shooters, and he was found potentially liable based on the provocation rule. And the Supreme Court held that the provocation rule was not a proper part of the Fourth Amendment, that you have to analyze the incident based upon the officer's decision at the time, what they knew at the time, what the situation was before them. And that officer had a situation where his fellow officer had gone into this building, announced that there was a gun, there appeared to be an immediate threat, and he responded to it. So that was favorable for the second officer. But for the first officer, what they said is that the proximate cause analysis still applies, that if you have an improper warrantless entry, which they arguably did here, that the officer can be liable for all of the subsequent events that are caused by that unlawful entry. So the court remanded the case to determine whether the shooting was caused by that unlawful entry. So I think that's the way that's going to play out in the future, and that's going to be a proximate cause argument. There's going to be some significant development of law regarding proximate cause in that area. Nelson versus Colorado was kind of an interesting case, and this had to do with exonerations. It says, to comport with due process, the state may not impose anything more than minimal procedures on the refund of exactions dependent on a conviction subsequently invalidated. What happened in this case, and this was a couple of consolidated cases, but the facts were pretty similar. They were convicted of felonies, minor felonies, I guess you could say, and they were ordered to pay some court costs and some restitution. And by the time their convictions were overturned and invalidated, they had each paid several $1,000s towards court costs and restitution and things. So they went back to the court system and said, hey, you know, we were exonerated, we were found innocent, you know, please give us back the money that we paid in restitution and court costs. And the state of Colorado said, that's nice, but you know, we have this exoneration statute, and you've got to follow the Exoneration Act, which requires that you prove by clear and convincing evidence that you are innocent. And if you do that, then we'll give you your money back. And the Supreme Court looked at this and went back to the old Matthews versus Eldridge balancing test and said, well, what are the private interests involved? What's the risk of an erroneous deprivation? And what is the government interest involved? And obviously, the individuals have a private interest in getting their money back. The government doesn't really have any interest in holding on to money that it has no right to. And there is a significant risk of an erroneous deprivation. And what the court really hinged on is, you know, once these people were exonerated, they are returned to the presumption of innocence. So we have to assume that they're innocent, and they're not obligated to prove that they're innocent. Because they've already been exonerated, they're entitled to the presumption of innocence. And so the court can't impose anything other than a minimal process to return their funds to them. And I think that, you know, this is an issue that may pop up in other places where we do have, you know, procedures in place to collect restitution and costs and a need to return them. I think that may become more common. And I think that may be kind of wrapped up in the debtor's prison movement, which relates to the cycle of people being arrested and having costs, fines, things imposed, and then being rearrested because they haven't paid it or haven't appeared for a hearing, and end up kind of in a cycle that goes around. That kind of debtor's prison area has been a fertile ground for litigation, and I think this may come in similarly. And there could even be class actions or something based on that, depending on the way the systems are structured. The next case of the Supreme Court was White versus Pauley. And this was a qualified immunity case. And one of the points that the court made in this case is that they had reversed a number of cases over recent years based upon the denial of qualified immunity. And they're saying, look, lower courts, you need to take qualified immunity seriously. You're denying it too often. And this was another case where that came up. And this was kind of interesting. This arose from a road rage incident. There was a male driver and a couple of female drivers evidently had a dispute on the road. The female drivers called the police. The police came out to the scene to investigate. The male driver had left. So they interviewed the women. And then the officers got together and had a meeting among themselves, decided that they did not yet have probable cause to make an arrest, but that they should go talk to this guy and investigate further. So they got his license plate, got the address for him, and went out to that address. And there were two houses out in this particular address. The first one, they didn't see his car, so they proceeded to the second one. And according to the allegations, the officers approached the house covertly. So they kind of snuck up on the house. But as they got there, the residents inside, Mr. Pauley and his brother, evidently noticed that there was somebody sneaking up on the house, and so they shouted out, who's out there? The officers claimed that they shouted, that they admitted that they kind of laughed about who was out there because, you know, it wasn't a big deal that they were there for. And they supposedly said, you know, we've got you surrounded, come out, you know, state police, come out. And the Pauley brothers testified that they never heard them identify themselves as police. And because of the posture of the case, the court had to assume that their version of the facts was true. So they had approached, they did not announce who they were, but told them, we've got you surrounded, come out. And then a short time later said, if you don't come out, we're coming in. So the Pauley brothers then said, well, we've got guns. At that point, another officer, Officer White, shows up. And that's the first thing he hears, is them saying, we've got guns. And then one of the Pauley brothers steps out on the back porch with a shotgun, fires a couple of blasts in the air, goes back in the house. And then one of the other officers sees his brother pointing a pistol out of the house, generally toward the officers, fires a couple of shots at him, misses, and then Officer White sees him, fires a few shots, and kills the Pauley brother. So the case came up primarily on whether Officer White was entitled to qualified immunity, whether he violated the Fourth Amendment when he fired the shots. And what the court said was that he was entitled to assume that the other officers who had been on the scene had followed proper procedures. In the absence of any evidence, any reason for him to believe that proper procedures had not been followed, he could assume that they had properly identified themselves, and so that when this person pointed the gun at them, that they were appropriately responding to return fire. And so the court held that the law was not clearly established that he could not do that, and therefore he was entitled to qualified immunity. And the probably most important thing about that case is just the reminder to the lower courts that they need to take qualified immunity seriously, that it's intended to be not just an immunity from liability, but an immunity from suit. And they need to address that early on and let the officers out if it appears that the law was not clearly established, that they should have known what they were doing was wrong. All right, so now we're going to move on to the Seventh Circuit cases, and we've got some interesting cases on due process, deliberate indifference claims, and Monell claims. And the first one is Petties versus Carter. And this has been a significant expansion of what is meant by deliberate indifference. In this case, dealt particularly with medical care, but I think it may end up being applied a little bit more broadly. And in the medical care cases, it's generally been true that if a doctor responds to an inmate's complaints, provides him with care, even if it's negligent or inappropriate, if they've made some effort to address the inmate's problems, they're not ignoring it, so they're not being deliberately indifferent to an inmate's serious medical need, which is the standard. I mean, there's always been, for many years, this kind of two-part standard. The inmate has to show that they have a serious medical need and that the doctor or jail staff or whoever is being sued was deliberately indifferent to it, meaning that they had actual knowledge of that problem and deliberately decided not to give appropriate assistance. Now, what happened to Mr. Petties is that he was in the Illinois Department of Corrections. He was going down the stairs one day, fell, and ruptured his Achilles tendon. So he was taken to the infirmary where he was seen by a doctor who was employed by Wexford Health Services, who was the contractor who works with the Department of Corrections. And the doctor believed pretty much right away that he had a ruptured Achilles tendon. He did his examination. He concluded that's probably what he had. And he gave Mr. Petties ice, crutches, and Vicodin. He did not give him a splint or a boot or anything to immobilize it, even though Wexford's policies and procedures indicated that for a ruptured Achilles tendon, you should give him something to immobilize that with. But he didn't do that. He gave him the ice, crutches, Vicodin, and I think a low bunk pass. He eventually referred him to a specialist. He got an MRI, which confirmed that he had a ruptured Achilles tendon. But the orthopedist who saw him said he may need surgery, and the doctor, Imhotep Carter, who was the defendant there, said, well, I think surgery is too expensive. We're not going to send you out for surgery. And again, that's because of the posture of the case, one of the allegations made by the plaintiff that the court had to assume was true. After that, he was later referred to an ankle specialist. He got a boot after he saw the first orthopedist, got another referral to an ankle specialist who again indicated that he may need surgery, and the doctors decided that they would continue with the boot but not give him surgery. And so they were initially granted summary judgment because they had given a fair amount of care to respond to his complaint. And the Seventh Circuit said, no, even though they gave care, the doctors violated the Wexford policy, and based largely in part on that, the jury could infer that the doctors were deliberately giving him care that they knew to be insufficient. And therefore, the jury could infer that the doctor was being deliberately indifferent to a serious medical need. And that seems somewhat inconsistent with previous cases which have said that negligence, violation of the standard of care, violation of the policy is generally not sufficient for deliberate indifference. So this is something that has significantly expanded liability, and this is a case that I get cited to me by plaintiffs' counsel regularly, almost weekly, I think, since that decision came out. There are kind of three categories that the court has pointed to where, even though care is provided, it may be insufficient and there may still be a deliberate indifference claim. Number one is where they persist in a pattern of treatment that they know is ineffective. Number two is where they choose a course of treatment that is easier or cheaper without exercising professional judgment. They do it solely because it's easy or cheap. Or where they impose a significant delay that serves no penological interest, that serves no purpose. The other important thing that came out of the Petty's case for contractors that work at the jail, like Wexford or Advanced Correctional Health Care or Corizon, is that qualified immunity does not apply to the individual medical providers. The individuals who are employed by the government, the correctional officers, CMTs, those kind of people, are generally entitled to qualified immunity, but the contractors are not, and that was a new development. There is some indication in an older Supreme Court case that the private individuals may be entitled to some kind of good faith immunity, but that's never been established. So that will be something that will have to be litigated in the future. And that's part of, I think, the plaintiffs' bar's attack on private contractors. One of the other areas they're really trying to push into is to get rid of Monell for private contractors and simply have them liable on a respondeat superior basis, where if their employees cause a violation, the company is automatically liable and they don't have to prove a customer policy as they do now. And that kind of gets us to what's going on with Monell right now. The old standard was pretty straightforward. It was kind of a two-step process. First, the plaintiff would have to establish that someone violated their constitutional rights. If they've established that, then they could make a claim against the municipality or the company if they could show that there was a custom or policy that caused that individual constitutional violation. And there are a couple of recent cases in which the Seventh Circuit has held that the first step is not necessary, that there can be Monell liability on a company or a municipality even if none of the employees committed any constitutional violation. And the earlier case for that, back from 2010, was Thomas versus Cook County Sheriff's Department, in which the court said a municipality can be held liable under Monell even when its officers are not, unless the finding would be inconsistent. And in that case, that arose out of the Cook County Jail and involved employees of the county, employees of the Sheriff's Department, all of whom were sued in addition to the sheriff and the county themselves. It involved an inmate who was brought to the Cook County Jail and died there of pneumococcal meningitis. They sued a number of people, including correctional medical technicians, CMTs, correctional officers, the sheriff, and the county. The correctional officers were employees of the Sheriff's Department. The CMTs were employees of the county. The case went to a jury trial, ended up in a verdict of $4.5 million for the plaintiff. and the defendants appealed. And the issue on appeal that the plaintiff raised was that the county and the sheriff's department had a custom and policy of ignoring medical requests. Medical requests were usually written out on paper and placed in boxes in the cell blocks, and the CMTs would have to go around and pick those up. And very often they didn't pick them up for one reason or another. Sometimes they didn't have a key to the box, or sometimes they were just busy or lazy or whatever. But they regularly did not pick those up for a few days, and therefore inmates were not getting timely medical care. The individual employees from Cook County were acquitted. The CMTs, because they had to rely on officers, they didn't always have access, so they end up being acquitted. And so the county raised the argument on appeal that, look, all of our employees were acquitted, so we can't be liable because none of our employees committed a constitutional violation. And that's when the Seventh Circuit said, no, even if your employees were acquitted, if your policy itself was deliberately indifferent, you can still be liable. And that became even more clear in Glisson versus Indiana Department of Corrections. That Thomas case didn't get picked up very much, wasn't noticed for that particular line in the case. The Glisson case definitely has. This is one that I'm starting to see cited quite a lot. And it involved an inmate who was sentenced to the Indiana Department of Corrections. The care there was provided by a company called Wexford. And this appeal dealt with the claims against Wexford. The inmate had a large number of pre-existing medical conditions. He had prior cancer that led to the removal of part of his jaw. He had a stoma in his neck that was used for, I think it was for feeding. He has a nasogastric tube that he had to eat with. But he was living independently before he went to the jail. He had learned to care for himself with fairly minimal assistance. The Indiana Department of Corrections had a policy guideline regarding coordination of care that required or recommended that care be coordinated between different facilities. Corizon did not adopt that policy expressly, but they provided care at all of these different facilities. When he initially came into the Indiana Department of Corrections, he went to kind of an assessment center where he was seen by medical and everyone else, and eventually classified and assigned to a different facility and was transferred to the second prison. In this process, he was seen by a number of different medical providers, each one who presumably did the best they could based on the information in front of them. The court held that none of them appeared to have been deliberately indifferent. They made reasonable decisions based upon the information ahead of them. And so the appeal was limited to the claim against Corizon. And the allegation was that Corizon itself was deliberately indifferent based upon its failure to adopt policies regarding the coordination of care to make sure that complete medical records went with this inmate, so all of the doctors had a complete chart and all the information that they needed, which apparently was part of the reason that this inmate did not get the care that they were provided, or that they needed. The inmate eventually died of basically starvation and renal failure because he couldn't get adequate nutrition. And the court said that if the institutional policies themselves are deliberately indifferent to the quality of care provided, then institutional liability is possible. And this is a big expansion of potential for liability for companies like Corizon, for counties that operate jails. And I expect that this theory of liability could be expanded into other areas of law enforcement. For example, if you had a policy for tracking warrants, or failed to have an adequate policy for tracking warrants, so that people were being arrested on warrants, thank you, even though the warrant had been recalled, but they were getting arrested because you didn't have a proper system for tracking it, the city might be liable even if the individual officers were not, because they believed that they were acting on a proper warrant. So I think that's going to be an area where there may be a significant expansion of liability, particularly for the municipalities and companies. Now we're going to move to state courts, a couple of interesting cases regarding malicious prosecution and searching liquor establishments. The first one is Beeman versus Friesmeyer, and this was out of Normal, and it arose from the murder of a young woman who was an ISU student a number of years ago, and her ex-boyfriend was arrested and convicted of that murder. He was eventually acquitted, and he filed suit in federal court. The federal court granted summary judgment for all of the officers and prosecutors involved and declined to exercise jurisdiction over the state law claims. So Beeman then refiled all of his state law claims, including the malicious prosecution claim, in state court. And his claim generally was that the officers knew that he was probably innocent, that they had information suggesting that someone else did the crime, that he was innocent, and that they misled the prosecutor into pursuing him. The malicious prosecution claim requires that he prove 5 elements. Number 1, that the defendant commenced a criminal proceeding against him. Number 2, that proceeding terminated in his favor. Number 3, that there was an absence of probable cause. Number 4, that there was malice. And number 5, there was damages. And this decision focused on the first one, whether the defendant commenced a criminal case against him. And the defendants in this case were police officers. The prosecution is typically commenced by a prosecutor, by the attorney who files the charges in court and proceeds with it. But occasionally we do see claims against police officers. In the past, there have been liable if the police officers played a significant role in initiating the prosecution, and that was kind of the language that was used, the significant role language. And Beeman has eliminated that language and said, to find that a police officer usurped the state's attorney's decision-making role and that the officer is responsible for commencing or continuing a criminal action, the plaintiff must establish that the officer pressured or exerted influence on the prosecutor's decision or made knowing misstatements upon which the prosecutor relied. So they've got to prove that the police officer pressured the state's attorney into making a prosecution that he would not have otherwise, or gave him bad information to mislead him. And so in this particular case, the 2 primary issues, one dealt with a time trial. An officer drove to Mr. Beeman's home and back to show that he could have committed this crime based upon the time that he was known to have been at home. The other dealt with an incomplete polygraph exam that was done of another potential suspect. And the court held that the time trial, while the defendant considered it misleading, was truthful. He was honest about where he drove, how fast he drove, and the issues the plaintiff was raising were subjects for cross-examination, not a malicious prosecution claim. And the polygraph exam was simply incomplete and would not have affected the prosecutor's decision at all. So the court affirmed summary judgment for the police officers in that case. And the last case I'm going to talk about is 59th and State Street Court versus Emanuel. And this was kind of an interesting case. It involved a search of a liquor establishment. And evidently the Illinois Liquor Code and the ordinances in Chicago allow the search of a liquor store at any time, for any reason. The officers can show up and search them whenever they want. So this liquor store was operating about 5:44 p.m. one night, and a task force of 12 people shows up to search them. There's 7 police officers, fire marshal, building inspector, code enforcement. 12 people come in and say, we're going to search your place. And so they go not only through the store, but they go upstairs where they had some sleeping areas. And in one of the upstairs areas, the officer finds a bullet in an ashtray. And so they start getting suspicious, and they search around some more. They make the owner open up a safe that was in the liquor store. They find a gun in the safe. They find another gun in the office. And so they arrest the guys who were operating the store because they didn't have a permit for the guns. They prosecute them criminally, and in the criminal case, the evidence was suppressed because they did not have a warrant to search the premises, and the court found that it was an improper search. This case arose from an administrative proceeding. After the criminal case, the City of Chicago decided to revoke their liquor license, and so they initiated that proceeding, and the facts were not in dispute, but the owner of the liquor store argued that the search violated the Fourth Amendment and that the evidence therefore should have been excluded. And the court, the First District, held that they were right, that this was a violation of the Fourth Amendment, that it was an unreasonable search because there was no limitations on the time, place, or scope of the search that could be done. And so that was a violation of the Fourth Amendment. But, they said, the exclusionary rule applies only to criminal cases, so the court didn't have to exclude this evidence from the administrative proceeding and allow them to revoke their license anyway. So the remedy for this was not to exclude that evidence in the administrative proceeding. The remedy is going to be a separate Section 1983 lawsuit for damages, and there have been some subsequent Section 1983 claims on that basis. So, am I out of time? 2 minutes? Okay, I'll tell you one more thing from the trial that I had a few weeks ago. One of the important takeaway lessons, and it's valuable for everybody who's kind of working on the ground in law enforcement, is that jurors believe paper more than people. And that was really hit home in this. This lawsuit involved a gentleman who was in our jail for 9 days and then transferred to the Illinois Department of Corrections for 16 days. And he died of a gastrointestinal bleed at Stateville Prison. And the plaintiff argued that during the 9 days he was at our county jail, he was vomiting blood, and the staff there ignored it, provided him with no care. Our argument on behalf of the jail staff and the medical providers that we were defending was that he was never vomiting blood at our jail. That all he asked for was an antacid. We gave him the antacid, and he was fine when he was at our jail. They had 2 inmates who testified that he was vomiting blood at our jail. We had 1 inmate who testified that he wasn't, and obviously the correctional officers and the medical staff testified that he wasn't. And we got the opportunity to interview the jurors after the trial, and what they really relied on were 2 pieces of documentation. Number 1 was the jail check sheets. When the officers go around, they have to go around and lay eyes on every inmate every 30 minutes, and they have to mark off on a check sheet that they've done that. And so they had done that regularly like they were supposed to, and no indication of any problems with Mr. Piercy. The other piece of documentation was a shift change email. They have 12-hour shifts, so twice a day at the end of each shift, the commander on that shift would send an email to the entire jail staff with a short summary of what happened during that day. You know, we moved Joe and Bob down to this cell, you know, Dr. So-and-so saw this person for toothache, you know, a lot of kind of mundane things, you know, in a paragraph or 2. And the jurors looked at all of that and read through it very carefully and said, look, you know, they put a lot of mundane, boring junk in this. If somebody was vomiting blood in the jail, certainly that would have been mentioned. So the documentation was very key to that. And so that was something that was really driven home. And I had actually another hearing up in Rockford this week for a PAVI hearing, and that was in front of the judge. And the issue in that case was whether the inmate received an inmate handbook that laid out the disciplinary procedures for him. And the officers testified that every inmate is given a handbook every time they're booked in. That's just our procedures. And the judge said, well, do you have any documentation that he signed saying that he got it? I'm like, well, no, that's just our procedure. We do it every time. He wasn't convinced. They want to see documentation. So to the extent that you can drive that home back in the office, the more you can document things, the better. So thank you very much. I'll be around for questions at the end. All right.